standard, you have to establish that law, that legal principle, is clearly establishes in this context, in this factual context, that the warning should have been given.
Sure. I mean, not only that, but I mean, he had the time, but again, we go back to there are disputed facts about whether she was being pummeled or whether there was any.
I'm kind of focusing on the law and not the facts.
Please.
So where's the clearly established law? So is what the principle of law I just stated, and I'll just state it again so we're clear. A warning must be given before deadly force is employed whenever practicable. Is that at too high a level of generality in order to qualify as clearly established law under the Supreme Court's and this court's qualified immunity precedents?
No, it's not, Your Honor. Whenever practical, if we apply that standard to the facts, and we see that Officer Agdeppa says she's being pummeled for 30 to 40 seconds and taking all these blows to the head, which aren't evidenced in her photos or anything like that, any type of injury such as that. So there's that credibility issue. There's all this time passing by that we're seeing about 30 to 40 seconds, I believe, Agdeppa testifies to in his depot of watching this pummeling.
What case would you point to that would have put the officer on the greatest notice that in this type of situation where we have a violent struggle and taser that was attempted, that a further warning of lethal force was constitutionally required?
We can go back to the notices provided in Officer Agdeppa's training manual. And in terms of case law, we can look at Mendoza and Gonzalez and Isabella. We can look that it's not even necessary sometimes in these situations that there's a bright line or clear precedent in a situation as grave as this, especially given the use of lethal force, which takes us into a different kind of level of balancing ultimately.
Do we have other case law where we've looked to a training manual to establish what the reasonable officer would have known?
Can't think of that off the top of my head. I apologize there. But that would establish the reasonableness there. Clearly, that's part of your training. If that's your manual and that's the policy of the state of California, for example, in our post-training manuals, that these warnings must be given, and it comports also again with Gonzalez when we go back there, whenever practicable. And with the passage of time here, we see that there was plenty of time for such a warning to be given, assuming that the facts aren't in dispute, which they are.
Counsel, let me ask you a different question, completely different question. I'm going to ask both lawyers, as we often do. Have you tried to mediate this case?
Yeah, we were subject to mandatory mediation by the district court. I'm uncertain in the record if we had already done that. I think we did that before the motion for summary judgment was filed.
Right, and so at this point, given that you're now on appeal and you've got a summary judgment ruling, has there been any, that's my question. Have you been in contact with the Ninth Circuit mediators?
No, I haven't.
Okay, thank you. I don't have any further questions, but I don't know if you do.
Sure. Did the plaintiff argue below or even in this court that Gonzalez sets forth clearly established law that would have put any reasonable officer on notice that a lethal force warning was required before shots were fired?
Let's see. Yeah, page 34 of our brief, we kind of lay that out. Or 24, I apologize. So,
yeah, I think that's the qualified immunity part one, the Saucier part one part of your brief, and not the part two, Saucier part two part of your brief. I know Saucier's been overruled, but
I have to double check the record on that.
I think page 85, 86. Sorry, ER. That's my ER site. I didn't mean to imply you had an 85-page.
I'm sorry, what's ER what?
I think it might be ER 85, 86.
right, and that would be in the district court.
And right. thought that was the question, forgive me. Your question was
Yeah,
not in the district court?
The question was both the district court and the Court of Appeals. Where did the plaintiff argue that the law was clearly established that officers in this situation would have given a lethal force warning before firing the shots?
I think it's around ER 55, somewhere in that transcript. I'm just trying to find that in terms of the warnings. There's been raised in the district court during the summary judgment adjudication.
Next is cite to Harris, which was what Gonzalez relied on. Whenever practicable, a warning must be given before deadly force is employed. But it's a Harris cite. It doesn't. Which is what Gonzalez relied on. I have that at ER 2526. Is that the incorrect cite?
So 25, 26. I'm sorry.
I'm sorry. Are you are you asking on appeal or district court?
I'd be happy with either.
Okay.
Yeah, I mean, if I could submit it after.
And just to be candid, I don't think it's in either. But I could be missing something, which is why I'm asking you.
I thought I found it in both places. So one of us, maybe we should go to mediation. Is there anything further, Councilor? Judge Bress, anything further?
No, no, thank
Okay. Thank you so much for your
Thank you.
argument today.
Thank you.
Thanks.
Council, you have some time left on the clock. We'll put 2 minutes on, please.
Thank you.
Then it continues on and actually citing that, or excuse me, it references Glenn versus Washington County, and which states other relevant factors include the availability of less intrusive alternatives to use force employed, whether proper warnings were given, and whether it should have been apparent to officers what the person they used force against was emotionally disturbed. Obviously, that's a different case involving emotional disturbance, but it includes the reference to whether warnings were given was a factor. In the George versus Morris case at 736 F. 3rd 829, the court confirmed that the most important factor is whether the suspect posed an immediate threat to the safety of the officers or others. The other question that's undefined is, what is a specific warning that must be given? Does it have to be words of, I'm going to shoot, stop, I'm the police, or something else?
It seems to me even that might be context specific, because there are some circumstances where we could see, and here we can't, we don't have a visual, but there might be other circumstances where a suspect can see the officer has drawn a gun, right? And we don't know that here, about just how they were positioned, whether that would have been visually apparent.
Thank you. What we do know is that the suspect understood there's two uniformed officers who were trying to detain him. We see that on the video. We see and hear the attempted taser, uses of taser. I believe there's 6 or 7 total tasers. He's warned.
Did they both use a taser?
Yes, Your Honor, they did.
And they both lost their tasers in the struggle too, which strikes me
Yes, they did.
as significant.
The suspect takes Officer Rodriguez's taser. Officer Agdeppa drops his when he's dazed and punched in the face. So at that point, you have a situation where the suspect knows the uniformed officers, knows they're trying to take him into custody. You've had a prolonged struggle. He knows that they have weapons out. They've already have their less lethal weapons out. Any reasonable officer, the question is what specific words need to be said and at what duration, and in the timing of a rapidly evolving situation. There is no clearly defined law that says at this point you must say these words, at this point you can simply act in self-defense.
It's all about what is practicable. Let me ask you the same question, whether you have been in contact or considered mediation in this case?
We have discussed it with the Court of Appeal mediation panel. We've been willing to sit down and talk with them. We also did mediate the case before coming to the Ninth Circuit. We're happy to sit down again.
Before the summary judgment ruling?
Before the summary judgment ruling and after the summary judgment ruling as well.
Okay, great. Anything further?
No.
Thank you so much for your arguments. Thank you both.
Thank you.